As you can imagine, there are a lot of regulations out there with regard to privacy information. Various U.S. government regulations like SOX, HIPAA, GLBA, Privacy Act. There are self-regulated privacy regulations like PCI, payment card industry. And then there's individual user privacy information, things that an individual user might want to keep secure or private, like passwords and encryption. Why do we need privacy regulation? Why do we have a list of 8 different regulations out there? Why does each state have their own privacy regulations? Well, most of this stems from a lot of incidents, privacy, data breaches, public or information becoming private that shouldn't, or information becoming public that shouldn't have been. But privacy really refers to the rights and obligations of people with respect to collecting, using, retaining, and disclosing their personal information. Security, of course, a big focus of security is on how to protect the privacy rights of an individual and prevent the disclosure of this. But what we see are, the reason all these regulations were put in place was because of various data breaches, technologies coming together which allow a lot of data aggregation to occur, where you've got data warehouses now with people's information all over it. It's the use of that information or the misuse of that information is the reason why all of these regulations now exist. Some of the things that complicate that are, again, that data aggregation, the fact that I've got multiple sources of information and I can pull from it and put together a bigger picture of me rather than just my name and address and social security number. Globalization, this notion that data is now flowing between countries, even between different states, is an issue as well. And then you have all of these, technological achievements we've had over the last few years with being able to collect this data, being able to process this data, mine through it. Our information processing capability is exponentially above where we were a year ago, 2 years ago, 3 years ago. And so our ability to collect and store and use this information really has enabled all of these issues with privacy that we're now seeing today. From a regulation standpoint, there are a series of regulations, federal government, state, international agreements regarding privacy and data, and we'll talk about each of those here. First up is SOX, the Sarbanes-Oxley Act. This is applicable to any company that's publicly traded on the U.S. market. And really, this came out of this regulation came out of the fiasco with Enron and WorldCom many years ago. And because of what they were doing with data or misusing it, as the case may be, now we have regulation with regards to managing, tracking, and reporting financial information on companies. We also have HIPAA, the Health Insurance Portability and Accountability Act. And this is providing standards and procedures for how our health information is stored and maintained and transmitted between different healthcare providers. And every time you go to the doctor now, you probably see a HIPAA form that says, here's how we're protecting your information and here's what we can do with it. And anytime you need to get Dr. X to share information with Dr. Y, guess what? You have to do a release form. All of that is because of the HIPAA regulation. The Computer Fraud and Abuse Act, CFAA, this is why we don't have large numbers of roving bands of hackers out there in the U.S., because this is the United States' anti-hacking statute and covers criminal penalties for misusing or abusing information systems, hacking into systems that don't belong to you, etc. The Federal Privacy Act of 1974, this is probably The most visible one, because every paper that you have to fill out for the U.S. government has a tag on the bottom of it that says, required by the Privacy Act of 1974, what we're going to do with this data, how we can disclose it. But generally, the Privacy Act covers how we gather information on U.S. citizens and what we can do with that information and how to safeguard it. The Personal Information Protection and Electronic Documents Act, this is a Canadian regulation to oversee how the private sector discloses and uses personal information. And so if you're a U.S. company and you have business dealings in Canada, you're probably subject to this regulation. Then there's also PCI, the Payment Card Industry Data Security Standards. If you process credit card information or work with a payment card provider, you are subject to these set of regulations. And you look at the evolution of PCI over the last 10 years or so. PCI 3 was just released a few months ago. The notion that the standards are evolving, they're getting bigger, they're getting more protective, if you will, of the data that they're intended to protect. But the PCI was intended to prevent identity theft, credit card fraud. And so the banks, the payment cards like Visa and MasterCard, saw this as a way to cut down on the credit card fraud that they were seeing. And so what they said was, we're not going to make this mandatory for all of the businesses out there, but it's self-regulated. So here's a set of standards. You can meet it if you're going to process payment card information. And the last one up here, the USA Patriot Act, this came out of September 11th. There was a lot of changes to existing laws as a result of this, but the bottom line there is the important one, that now it requires one federal warrant from a judge to collect information from sources across the U.S. So instead of having to file warrants for 10 different service providers or phone companies or whatever, now the federal system only has one that they need to collect or process in order to access that information. GLBA, Graham-Leach-Bliley Act of 99. This was a regulation put in place for consumer protection. And so this, now when you deal with a bank, you probably have some form that says, how we can share your information, how you as a bank customer can restrict sharing of that information. All of that is coming out of the Graham-Leach Act of 99. And then the big one for U.S. federal government is FISMA, and that requires all federal agencies now to safeguard personal information and information systems. That's a very broad act. So add on top of all of this federal regulation, you also have state regulations as well. And I think Massachusetts and California are probably the most notorious, if you will, for stringent privacy protection, data protection. If you're doing business in Massachusetts, then you are subject to the Massachusetts Data Protection Law. And again, this is designed to protect identity theft and fraud. If you're doing business in Nevada, you have the Nevada Personal Information Data Privacy Encryption Law. Whew, that's a mouthful. So now you've got these various states enacting laws about how to protect information. And the Nevada one specifically requires any type of PII that leaves your boundary as a business, that's got to be encrypted. So there are 7 or 8 federal regulations. Just about every state has its own privacy protection. What do you do as a company? You have to be compliant with all of them, right? Otherwise, a state regulator or a federal regulator can take you to court over it. So what do companies do? Well, what we find is that most organizations pick the most stringent one that's applicable to them and abide by that across the board. So let's just say that the Massachusetts law is more stringent than any other state out there. That may or may not be the case. But let's say that it is. So as a U.S. company doing business across all 50 states, I'm going to be compliant with the Massachusetts law being the strictest one, and I know that I'm covered regardless of where I operate within the country. There are a couple different frameworks out there that you can use for privacy and data protection. There isn't a whole lot here other than the standards, but there's this Organization for Economic Cooperation and Development, OECD. It's the most commonly used framework internationally. It aligns very closely with the European Union data protection requirements and legislation. And then there's this GAP, Generally Accepted Privacy Principles. It's very similar to OECD, but it's more focused on implementation, and it's a voluntary framework. So OECD and the EU data protection legislation is mandatory. GAP, GAPP, was created by a group of certified public accountants, CPAs. So not to be confused with the Generally Accepted Accounting Principles, the other GAP. This was created by the same group of people, but it's voluntary. There is a safe harbor privacy principle. So this was enacted to help facilitate companies that are doing U.S. and EU business. So it's a cross-border data transfer agreement, and it stipulates how to handle customer data, but only for organizations under the FTC, Federal Trade Commission, or Department of Transportation purview. So just because you do business cross-border, U.S. and EU, doesn't mean you can use the safe harbor principles or safe harbor privileges there. Asia Pacific, not to be outdone, has their own APEC privacy framework, and it concentrates on the harm of releasing privacy or private information rather than the rights of an individual to that information. So what do all of these privacy regulations, what are they intended to do? So if you boil it all down, it comes down to these four ideas here. That the collection of personal data should be limited, and it should be done by lawful means. And the person should have consent to that. I'm voluntarily giving you my personal information. The information that you collect should be relevant for what it needs to be used for. Accurate and complete and kept up to date. So the consumer ought to have a way to keep all of that information current. The data should be used at a specific time when it's collected, and what's unsaid here is you really ought to get rid of it if you're not using it. But generally, collect the information, use it for what it's needed to be used for, and then toss it if you don't need to store it for any reason. And then the bottom one there, personal data should not be disclosed. This is kind of an obvious, well, yeah, that goes without saying. You don't want to disclose privacy information, personal information, to non-authorized people, entities. This is how data breaches occur. Personal data should be reasonably protected. This goes to, you don't want to leave information on publicly available systems where it could be compromised and used for identity theft. And then the consumer rights portion of this, or consumer rights perspective on this is, I really ought to know whether you as a company have my personal information. What information of me do you have? Do you have my name, email address, phone number, social security number, or do you just have my name? So I ought to be able to know what you have collected on me. Then I ought to be able to get a copy of that information in some reasonable timeline at a reasonable cost so that I can make sure that it's accurate. And then I should be able to update that information in some way, shape, or form. And I should have the right to challenge you if you say, I can't have that information. And so there's a set of consumer rights here that go along with the international privacy regulations. So we've talked a lot about PII, but what really is personally identifiable information? Well, at a minimum, it's things like social security number, phone number, full name, date of birth, mailing address, and those types of things. And it's, because that information is needed for identification purposes, a lot of businesses collect that information. And I've heard it said that it takes two of those pieces of information together to cause some type of data breach. So if I have a list of all of this information, but only the names are publicly disclosed, is that a breach? According to most regulation, no. It takes two pieces of information. So if it's my name and social security number, now we have a data breach according to most of the privacy regulations out there. And just a final note here on PII. Some countries, some regulations stipulate that any business, regardless of who you are and what you do, you're subject to these. But some countries and some frameworks only say certain type of industry. So what this creates is a big mess of privacy regulation where, depending on who you are, what you do, and where you do it, you may or may not be subject to any of the privacy regulation out there. My advice here is, if you're not a privacy regulation expert, go find one. They'll be able to navigate you through this mess with some sort of effectiveness.